This video is made for educational purposes only and cannot be taken as legal advice. You will find a link to the full judgment in the description. Fagan v. Commissioner of Metropolitan Police. Lord Parker CJ. I will ask James J. to read the judgment which he has prepared, and with which I entirely agree. James J. The appellant, Vincent Martel Fagan, was convicted by the Willesden magistrates of assaulting David Morris, a police constable, in the execution of his duty on August 31, 1967. He appealed to Quarter Sessions. On October 25, 1967, his appeal was heard by Middlesex Quarter Sessions and was dismissed. This matter now comes before the Court on Appeal by way of case stated from that decision of Quarter Sessions. The sole question is whether the prosecution proved facts which in law amounted to an assault. On August 31, 1967, the appellant was reversing a motor car in Fortune-Gate Road, London, Northwest 10, when Police Constable Morris directed him to drive the car forwards to the curbside and standing in front of the car pointed out a suitable place in which to park. At first the appellant stopped the car too far from the curb for the officer's liking. Morris asked him to park closer and indicated a precise spot. The appellant drove forward towards him and stopped it with the offside wheel on Morris's left foot. "Get off, you are on my foot," said the officer. "Fuck you, you can wait," said the appellant. The engine of the car stopped running. Morris repeated several times, "Get off my foot." The appellant said reluctantly, "Okay man, okay," and then slowly turned on the ignition of the vehicle and reversed it off the officer's foot. The appellant had either turned the ignition off to stop the engine or turned it off after the engine had stopped running. The justices at Quarter Sessions on those facts were left in doubt as to whether the mounting of the wheel onto the officer's foot was deliberate or accidental. They were satisfied, however, beyond all reasonable doubt that the appellant knowingly, provocatively and unnecessarily allowed the wheel to remain on the foot after the officer said, "Get off, you are on my foot." They found that on those facts an assault was proved. Mr. Abbas for the appellant relied upon the passage in Stone's Justice's Manual, 1968, Volume 1, p. 651, where assault is defined. He contends that on the finding of the justices the initial mounting of the wheel could not be an assault and that the act of the wheel mounting the foot came to an end without there being any mens rea. It is argued that thereafter there was no act on the part of the appellant which could constitute an actus reus but only the omission or failure to remove the wheel as soon as he was asked. That failure, it is said, could not in law be an assault, nor could it in law provide the necessary mens rea to convert the original act of mounting the foot into an assault. Mr. Rant for the respondent argues that the first mounting of the foot was an actus reus which act continued until the moment of time at which the wheel was removed. During that continuing act, it is said, the appellant formed the necessary intention to constitute the element of mens rea, and once that element was added to the continuing act, an assault took place. In the alternative, Mr. Rant argues that there can be situations in which there is a duty to act and that in such situations an omission to act in breach of duty would in law amount to an assault. It is unnecessary to formulate any concluded views on this alternative. In our judgment the question arising, which has been argued on general principles, falls to be decided on the facts of the particular case. An assault is any act which intentionally or possibly recklessly causes another person to apprehend immediate and unlawful personal violence. Although assault is an independent crime and is to be treated as such, for practical purposes today assault is generally synonymous with the term battery and is a term used to mean the actual intended use of unlawful force to another person without his consent. On the facts of the present case the assault alleged involved a battery. Where an assault involves a battery, it matters not, in our judgment, whether the battery is inflicted directly by the body of the offender or through the medium of some weapon or instrument controlled by the action of the offender. An assault may be committed by the laying of a hand upon another, and the action does not cease to be an assault if it is a stick held in the hand and not the hand itself which is laid on the person of the victim. So for our part we see no difference in principle between the action of stepping onto a person's toe and maintaining that position and the action of driving a car onto a person's foot and sitting in the car whilst its position on the foot is maintained. To constitute the offence of assault some intentional act must have been performed, a mere omission to act cannot amount to an assault. Without going into the question whether words alone can constitute an assault, it is clear that the words spoken by the appellant could not alone amount to an assault, they can only shed a light on the appellant's action. For our part, we think the crucial question is whether in this case the act of the appellant can be said to be complete and spent at the moment of time when the car wheel came to rest on the foot, or whether his act is to be regarded as a continuing act operating until the wheel was removed. In our judgment, a distinction is to be drawn between acts which are complete, though results may continue to flow, and those acts which are continuing. Once the act is complete, it cannot thereafter be said to be a threat to inflict unlawful force upon the victim. If the act, as distinct from the results thereof, is a continuing act, there is a continuing threat to inflict unlawful force. If the assault involves a battery and that battery continues, there is a continuing act of assault. For an assault to be committed, both the elements of actus reus and mens rea must be present at the same time. The actus reus is the action causing the effect on the victim's mind. See the observations of Park B. in Regina v. St. George, 1840. The mens rea is the intention to cause that effect. It is not necessary that mens rea should be present at the inception of the actus reus, it can be superimposed upon an existing act. On the other hand, the subsequent inception of mens rea cannot convert an act which has been completed without mens rea into an assault. In our judgment, the Willesden magistrates and quarter sessions were right in law. On the facts found, the action of the appellant may have been initially unintentional, but the time came when, knowing that the wheel was on the officer's foot, the appellant, 1. Remained seated in the car so that his body through the medium of the car was in contact with the officer, 2. Switched off the ignition of the car, 3. Maintained the wheel of the car on the foot, and 4. Used words indicating the intention of keeping the wheel in that position. For our part, we cannot regard such conduct as mere omission or inactivity. There was an act constituting a battery which at its inception was not criminal because there was no element of intention, but which became criminal from the moment the intention was formed to produce the apprehension which was flowing from the continuing act. The fallacy of the appellant's argument is that it seeks to equate the facts of this case with such a case as where a motorist has accidentally run over a person and, that action having been completed, fails to assist the victim with the intent that the victim should suffer. We would dismiss this appeal. Bridge J. I fully agree with my lords as to the relevant principles to be applied. No mere omission to act can amount to an assault. Both the elements of actus reus and mens rea must be present at the same time, but the one may be superimposed on the other. It is in the application of these principles to the highly unusual facts of this case that I have, with regret, reached a different conclusion from the majority of the court. I have no sympathy at all for the appellant, who behaved disgracefully. But I have been unable to find any way of regarding the facts which satisfies me that they amounted to the crime of assault. This has not been for want of trying. But at every attempt I have encountered the inescapable question: after the wheel of the appellant's car had accidentally come to rest on the constable's foot, what was it that the appellant did which constituted the act of assault? However the question is approached, the answer I feel obliged to give is, precisely nothing. The car rested on the foot by its own weight and remained stationary by its own inertia. The appellant's fault was that he omitted to manipulate the controls to set it in motion again. Neither the fact that the appellant remained in the driver's seat nor that he switched off the ignition seemed to me to be of any relevance. The constable's plight would have been no better, but might well have been worse, if the appellant had alighted from the car leaving the ignition switched on. Similarly, I can get no help from the suggested analogies. If one man accidentally treads on another's toe or touches him with a stick, but deliberately maintains pressure with foot or stick after the victim protests, there is clearly an assault. But there is no true parallel between such cases and the present case. It is not, to my mind, a legitimate use of language to speak of the appellant holding or maintaining the car wheel on the constable's foot. The expression which corresponds to the reality is that used by the justices in the case stated. They say, quite rightly, that he allowed the wheel to remain. With a reluctantly dissenting voice I would allow this appeal and quash the appellant's conviction. Appeal dismissed.